Now we'll bring up House File 238, Representative Nash. And in this one, I think with the instructions I read, we were going to have 20 minutes to present and then start with the public testimony.
Okay.
Oh, Representative Nash, this one has an amendment at all. You would like me to move that amendment?
Mr. Chair, if you would be so kind to put that in the shape that I desire.
Okay, the chair will move House File 238 for possible inclusion in the omnibus bill and also move the A17-0167 amendment, which should be in your packets. All in favor say aye. Aye. Opposed? Okay, to your amended bill, Representative Nash.
Thank you, Mr. Chair, and I'm going to give just kind of a high-level overview again, and then we'll bring up testifiers. This is House File 238, which is also going to be known as the Defense of Dwelling in Person Act. It modifies Minnesota's self-defense laws in order to codify years of case law into statutory language, making it easier for law-abiding Minnesotans to understand self-defense law. Here's what the bill does, a number of things. First, it puts decades of case law into clear statutory language. Today, to understand when it is legal to defend yourself at home or in public, one must understand a core set of Minnesota statutes. Then one must understand and commit to memory nearly a dozen Minnesota Supreme Court and Court of Appeals cases. In fact, you need to understand Minnesota court cases all the way back to 1865 in order to understand what you are able or required to do. In a self-defense situation, law-abiding citizen literally must process all of this information in an incredibly brief period of time, almost instantaneously. Second, it removes the duty to retreat requirement from Minnesota law. The idea of duty to retreat is not part of statutory law in Minnesota. It was the result of court cases and exists, like most of our self-defense law, only in case law. A law-abiding citizen not engaged in criminal behavior in a public place should not be forced to retreat prior to being able to defend themselves. Finally, this bill explains the definition of one's place of abode or home to include other locations that an individual may be residing in temporarily. There's been a lot of misinformation floating around there about gun control groups and others about what this bill does and doesn't do, so I want to be very, very clear once again. Under this bill, a person must be in imminent fear of death or great bodily harm, and the force used must be reasonable as defined in statute. A person must be reluctant participant, meaning that they could not have been provoked or initiated the situation. I'm also aware that our friends in law enforcement are here to testify against this bill just as they did in 2011, citing concerns with officer safety. Under this bill, under no circumstances, if you know the person is a police officer, is an individual allowed to use deadly force against them when they are acting lawfully. 33 other states have similar laws, the support for which has been bipartisan. In fact, in 2004, Barack Obama, then an Illinois senator, co-sponsored and voted for legislation that expanded Illinois' Stand Your Ground law. As I asked with House File 188 earlier, you're going to hear a lot of information during this testimony. I'd encourage you to take a hard look at the data from Dr. Lott, who will be coming forward here in just a second. He has spent a lifetime studying laws like this, and then to make your decisions accordingly. Thank you.
Thank you. Okay, you want who's?
Yeah, Mr. Chair, thank you. This is Dr. Olson, who's come down again, Professor Joe Olson. He'll be our first testifier.
Okay, and we have had the timer on for your 20 minutes, so begin, Mr. Olson.
Thank you very much, Mr. Chairman. Currently, in order to understand our self-defense law, you have to navigate statutory and case law, some of which are in conflict. This bill is intended to clarify some of those issues. It doesn't lower the threshold for self-defense, clarifies and defines it more carefully. The test currently for self-defense is that you have to reasonably believe that you are in danger of serious injury, or you have to be in your place of abode. What this statute does is carry that same language over. It's crossed out at the beginning. It comes back in subdivision 2, where it says repeatedly You can resist or prevent the commission of a felony which the individual reasonably believes is a felony in his individual dwelling. That's current law. You can resist or prevent an act which the individual reasonably believes is an offense or attempted offense that imminently, that's added, actually, that's part of the case law, but it's now put in the statute, exposes the individual or another person to substantial bodily harms, great bodily harm or death. Or third, to resist or prevent an act which the individual reasonably believes, once again, is the commission or imminent commission of a forcible felony. The forcible felony language and definition is new. What it does is it takes those felonies which have as elements of the offense death, threatened death or injury to the individual, and puts them in a list. So our person on the street doesn't have to say, what are the elements of that offense, and is it the kind of offense that could cause me to reasonably fear death or serious injury? It's an element of the offense. So yes, I can defend against that. It makes that clear for our citizens. Subdivision 3 essentially codifies current law and practice. This is exactly what police officers are trained to do when their lives are in danger. The same ability, flexibility should be available to individuals. And the presumptions are just that. They are rebuttable. They are not irrebuttable. And they assist the individual who's faced with a life-threatening situation to act appropriately to defend themselves without having to have a law degree, without having to have a lawyer in their pocket. Thank you.
Thank you, Dr. Olson. And next, Dr. John Lott, President of the Crime Prevention Research Center.
Good morning. Good morning.
Welcome, sir, and begin if you want to introduce yourself.
Thank you very much. Yes, my name is John Lott. I'm president of the Crime Prevention Research Center. I wanted to thank Chairman Cornish, Ranking Member Hillstrom, Representative Nash, who invited me, and distinguished members of the committee for the opportunity to discuss stand your ground laws. These laws basically help the most vulnerable people in our society to be able to defend themselves. The people who use them the most are the people most likely to be victims of violent crime. That overwhelmingly tends to be poor blacks who live in high crime urban areas. There are 33 states that have stand your ground type rules. Most of them are through legislation, though 6 of them have been through court decisions. And in fact, you have some places in the United States that have stand your ground rules for over 150 years. The support up until the last few years has been overwhelmingly bipartisan. You can find a number of states, in fact 12 states, where at least one of the bodies of the legislature have passed these rules unanimously. The last few years, though, there's been more of a debate on this, and they've largely stemmed from incidents in Florida involving Trayvon Martin and Jordan Davis. The irony is that in the Trayvon Martin case, the stand your ground rules were not relevant. The notion that somebody should retreat as far as possible. As was just mentioned earlier, if a person initiates the fight that occurs, they can't then go and claim stand your ground type protections. So you have 2 possible interpretations in the Trayvon Martin case. Either Trayvon Martin had George Zimmerman pinned to the ground and there was no place for him to retreat, or the other alternative is somehow George Zimmerman initiated the attack. In that case, you also wouldn't have been able to use stand your ground as a defense. In the Jordan Davis case, somebody tried to use stand your ground, but in fact he was still convicted of firing the gun. And the theater shooting that people have talked about is in court right now, but we could talk about that. So I'm not going to go and talk about the main points of the law other than what I mentioned with initiation. But claims of racism with regard to stand your ground basically have it backwards. Again, the groups that are disproportionately victims of violent crime are the ones most likely to rely on stand your ground. Florida has the most detailed data on this. Blacks make about 16.7% of the Florida population, but they account for 34% of the state's defendants invoking stand your ground rules. Black defendants who invoke the statute are also more likely to be acquitted than whites by about 4 percentage points. The data that's been collected goes from 2006, January 2006, when the Stand Your Ground law went into effect, through the end of 2014. There were 119 cases. The claim of racism using this often looks at the fact that 67% of those who killed a black person faced no penalty, compared to 57% of those who killed a white person. The problem that this ignores is that murders almost always involve people of the same race. 80% of the people who killed blacks involving stand your ground cases were themselves black. About 80% of those who killed whites were white. And when you take that into account, you realize that if you want to go and declare racism based on who's most likely to be acquitted, who kills a black, you have to realize it's primarily blacks who are using that defense in having killed a black in self-defense. And so you get 64% of blacks who raised stand your ground defense were not convicted, compared to 60% of whites. The cases are not similar in other ways also. Blacks killed in confrontations involving stand your ground cases were 26% more likely to be armed than whites. By a 25 percentage point margin, the blacks killed were also more likely to be involved in the process of committing a crime. And they were also slightly more likely to have witnesses present when the attack occurred. And when you run statistical tests that account for all these different factors at the same time, what you essentially find is that white defendants are more likely in stand your ground cases to be convicted. People invoking stand your ground laws who killed blacks were also more likely to be convicted than people who killed whites. And as one would hope, whether the person killed initiated the confrontation and whether there was an eyewitness were by far the most important factors for determining whether or not there was a conviction. I just briefly mentioned something, well, I guess I'll just go on to other research. There's a number of studies that have been done linking stand your ground laws to murder or homicide rates. There are about equal numbers of studies on both sides. Slightly more find a benefit than find a bad effect. But there are a couple things to point out here. The ones that find the benefit all look at national data, basically look at it for all the years that the data is available. The ones that find that there's been a bad effect either look at just one state, in the case of the Journal of the American Medical Association, and for a limited number of years, starting in 1999, or they look at only a very narrow period of time, and I'll get into that. In the research that I published in the University of Chicago Press and other papers by Carl Moody and others, in my case, I look at data from 1977 through 2012. What I find is that after you have stand your ground rules go into effect, murder rates fall on average by about 1.5 percentage points per year annually during the first 10 years that those laws are in effect. The JAMA study, which was alluded to earlier in the public comments on the previous bill, finds that there is an increase in homicides from about 5.9 per 100,000 to about 6.3 per 100,000 before and after the law goes into effect. That's about a 6.9% increase. But the thing is, they only look at one state, and they don't control for any other factors. So, for example, one factor that one may want to take into account is that between 2005 and 2006, there was a huge drop in arrests for murder in Florida. The arrest rate for murders in Florida fell from 82.4% in 2005 to 66.9% in 2006. So while you had a 6.9% increase in homicides, at the same time you had a 19% drop in the arrest rate for murders. And also one should point out that this study is looking at homicides rather than murders. And I'm not sure most people understand that there's a distinction between homicides and murders. The big difference is whether or not you have justifiable homicides involved, whether it be by police or be by civilians. And I think it's a mistake then to go and look at homicides rather than murders when you're looking at this, because you have to ask yourself if there are more justifiable homicides that occurred, and that's partly what's driving the difference between looking at homicides and murders. If somebody's protecting themselves from a crime or a police officer is being threatened, I'm not sure that that's bad in the same way that a drop in murders would be significant. The other study was by Texas A&M. They only looked at laws adopted between 2005 and 2010. They ignored states that had these rules imposed by court action.
Dr. Lott? You could
sorry.
keep going, but I just want to let you know that we've got about 5 minutes and 2 people behind you to go
Okay,
into that.
I'm sorry.
That's okay.
I can, anyway, you know, the important thing is they didn't look at anything after 2010. Again, you have this difference between homicides and murders. And, you know, again, there's questions about not being controlled. So why somebody would throw out all the data and all the laws prior to 2005 isn't really obvious. My general rule is that if somebody throws out data, they better have a good reason for throwing it out. And so you have, in any case, the data is divided on this question. But I appreciate your time, and thank you very much.
Thank you very much, Doctor, for coming all the way out. We have about 3.5 minutes for the next 2 folks, if they want to come up together, or Brian Strouser of the Minnesota Gun Owners Caucus.
Mr. Chair, I believe that Mr. Strasser is going to cede his time to Mr. Roush.
Okay, Mr. Roush from the NRA. Give you about a little over 2 minutes. Go ahead.
Again, good morning. I'll make this quick. Thank you, Mr. Chairman and members of the committee. Thank you for taking public comment on House File 238. First, I want to thank the bill author, Representative Jim Nash, for having the courage and strength in his principles to introduce this legislation. Taking out attacks from both sides is never easy, but I'm proud to say the NRA and our members stand with Representative Nash in his efforts. 27 states have legislatively enacted stand your ground laws, and in each case, NRA has been there to support each measure. We do so again here in Minnesota because it is a fundamental right for an individual to defend his or her life, family, property, and the well-being of others, no matter where that person has a lawful right to be. Once again, it comes down to the rights of an individual, and we'll support that every single time. Yesterday, I heard all the arguments opposed to stand your ground as I was in Des Moines, Iowa, where their legislature is looking to enact a similar law. Opponents make claims and even accuse supporters of hiding behind the Second Amendment. That attack is incredibly false. Supporters of stand your ground do not hide behind the Second Amendment. We stand firmly in front of it and defend it with legislation such as this. Again, I thank the committee for the hearing. For hearing testimony, and I look forward to the public comments and respectful debate continuing. Thank you.
Okay, thank you, sir. Fred from Burnsville, again. Are you here? If you folks could get ready to come down, and then we're followed by Tim Spreck, would be next, from the Minnesota Weapons Collectors. Go ahead, sir, your 2 minutes.
I heard a comment that we're not a safe country. I'll direct everybody to take a look at the World Health Organization, WHO, murder rates for the world. Starts at 98 and it goes down to 2.2. We're at 4.2. We're at the bottom of the list. We're one of the safest countries in the world, and we have the most guns. Most of the countries that have higher rates than us are already disarmed. So I think that's a great, great piece of information to use and so forth. Also wanted to mention a few things that society is dangerous, and we can't legislate perfection. And I talked about some of the murder rates and how they've gone down, and the homicide rates, and that the good guy shootings are in there. But we also have to remember, too, there's 4,000 deaths by feet and knives and clubs. There's 11,000 DWI deaths per year. There's 38,000 auto deaths per year. There's 10,000 kids under the age of 14 get killed on bicycles every year. There's 3,600, over 3,600 drowning deaths, 10 per day in the United States every year. 480,000, almost 500,000 from smoking in the United States. And 12,000 people per year in the United States just die from falling down. So we have to remember that in the states that have done castle doctrines and things like that, their significant crime dropped 60, 70, 80% in just a few years. And I think one of the ways that I explain people is, right now in Minnesota, you're required by law to flee your home if somebody breaks in. It's 25 below, you got bare feet, sleeping wear, you got about 30 seconds to get the dog, the kids, the wife, and get out the back window. And then you're going to be out there for about a minute, and you're going to realize that you just left your home, and what do you do now? And 2 in the morning, is your neighbor going to let you in?
Thank you, sir.
Thank you.
Appreciate it. Mr. Tim Spreck, followed by Mr. Joseph from Protect Minnesota. Mr. Spreck, go ahead, introduce yourself and begin your 2 minutes.
Mr. Chair and members, Tim Spreck, today speaking for the interests of the Minnesota Weapons Collectors. The Minnesota Weapons Collectors is a pretty large organization that holds a number of gun shows throughout the year. This gives them a unique opportunity to really take the temperature of what the folks out there in Minnesota and the neighboring states are thinking with regard to gun ownership and gun rights and related issues. And on this issue, the board has instructed me today to make sure that you folks all know that they support this law, the way that it codifies case law and actually gives the rights back to the human beings that are in their homes trying to protect themselves and their properties. And with that, I'll step aside, urge you to move this bill through. It's a good piece of legislation. We'd like to see it enacted. Thank you.
Okay, thank you, Mr. Spreck. Rachel Joseph, I'm sorry, I said Mr. Joseph.
That's okay.
You go ahead and introduce yourself and begin your testimony.
My name is Rachel Joseph. I'm the Director of Outreach at Protect Minnesota, and I work with survivors of gun violence. I'm also a gun violence survivor. My aunt, Shelley Joseph Cordell, was shot and killed at the Hennepin County Government Center courthouse on September 29, 2003. During the trial, I learned that the woman who murdered her bought her gun through a private sale at a Minnesota gun show for $60, no background check. Having Shelley taken from our family is a loss we will never recover from. In my work with others personally impacted by gun violence, I've seen the devastating toll gun violence has on families, and I have very grave concerns about HF 238, Stand Your Ground in Minnesota. In November 2015, my friend Cameron Clark was one of 5 protesters shot near Minneapolis's 4th Precinct. Alan Scarcella and 3 friends went to the protest wearing face masks and lured a group of black men up a side street, where he fired at them with a handgun, hitting and injuring 5, including Cameron. In court, Scarcella used the Stand Your Ground defense, claiming it was a justifiable homicide because he felt threatened. Despite having sent a text to friends that read, "The gun I'm getting is proven to kill black guys in a single shot." Scarcella's justifiable homicide defense would likely have exonerated him in a Stand Your Ground state. HF 238 would change Minnesota's existing use of force law by removing the obligation to retreat from danger before using deadly force outside the home and giving the presumption of innocence to the shooter. HF 238 represents a particular threat to communities of color and immigrants. If it were to pass, almost any shooting could be justified, even if the threat was simply someone's skin color or religion. In 2015, the American Bar Association reported that the application of Stand Your Ground laws is unpredictable, uneven, and results in racial disparities.
Okay, ma'am, your time is up. Sorry.
Okay, on behalf of myself, my aunt, and Cameron, I ask you all to vote no. Thank you.
Thank you, ma'am.
Mr. Chair, if I could just very quickly, and not to It's obviously a very sorry story, and I feel badly for her, but I believe it's been proven that the Scarcella case he was not an unwilling participant, that they initiated that, so I just wanted to make sure that that was on record.
Okay, Mr. Chief Snell,
Mr. Chair,
we'll give you 15, 20
but
seconds.
could you just get a clarification of what Representative Nash meant by that?
Okay, go ahead.
No, so what did he mean by that?
So Mr. Chair and Representative Pinto, the stand your ground thing that we're talking about says that if you read the bill, that they have to be an unwilling participant in order to claim stand your ground. The Scarcella case was actually initiated by the folks who carried out the shooting.
Okay, so you're saying, Mr. Chair, I think you're saying then that the stand your ground would not have been available, is your assertion?
And
Okay.
Mr. Chair, thank you. And that's, yes, and I should have been a little more elaborative. I was trying to be brief, but yes, that's what I was saying.
Make sure. Thank you, Mr. Chair.
Okay,
Welcome back.
Chief Paul Snell, followed by Ross Kuhn from West St. Paul. Chief Snell.
Chair Cornish, committee members, Paul Schnell again, on behalf of the Minnesota Chiefs of Police Association. The Chiefs of Police Association is not in support of House File 238 for a couple basic reasons. First and foremost, we believe that Minnesota has a current law that adequately protects reasonable and law-abiding people who act in self-defense. We offer two relatively recent examples that demonstrate the relevancy of the current law. In May of 2015, a 20-year-old patron of a Maplewood nightclub was shot and killed when the patron and 4 associates went after an armed permit holder security guard. After that case was fully investigated, it was reviewed by the county attorney's office, resulting in no charges against the security guard who acted in self-defense. Second, on a summer evening in July of 2015, a man and woman were sitting on the bluff of the Mississippi River just 4 miles from this building, where Summit Avenue ends and meets Mississippi River Boulevard. As they were sitting in that location, 4 young men approached them with the intent to commit an armed robbery. When the armed suspect demanded that the couple turn over their belongings, the male victim, who was an authorized carry permit holder, was able to draw his weapon and fire on the armed suspect. Following the shooting, the permit holder called police and rendered aid to his attacker. The suspect died at the scene. Once again, a thorough investigation followed, and the permit holder was not charged. Second, as you know, there has been considerable attention given to police use of force. Across our nation, there has been call for increased training in the use of de-escalation tactics by police. We believe that House File 238 is inconsistent with the increased and reasonable demand for de-escalation where appropriate. While we recognize that police officers are provided considerable levels of training in firearms use and tactics, we believe that House File 238 is inconsistent with the values of our communities, who expect that we take reasonable steps to de-escalate and use force only when deadly force is reasonable.
Okay, Chief.
We urge you to stand in opposition to this.
Thank you, sir. Okay, Ross Kuhn, West St. Paul, followed by Heather. Did you want to make that substitution again, or are you going to testify? Okay, first of all, Ross, followed by Ms. Martins.
Good morning.
Go ahead,
Morning.
Mr. Kuhn, with your...
Good. Hi, my name is Ross Kuhn. I'm here on behalf of myself and family members in West St. Paul, Zimmerman, and Elk River. Americans have a long, proud history of lethal self-defense, dating back through centuries of brave Americans defending what's theirs. Early on, lethal self-defense was a necessity when protecting our homesteads against marauding savages claiming to own the land that was rightfully ours. For decades, brave Americans needed to carry lethal arms to defend ourselves against the possibility of a lawless uprising of our valuable workforce. Had it not been for liberal use of force, we would not have been able to control our sea of laborers in the fields. As our country evolved, we had to adopt more tactics to maintain the integrity of our society and our government. It was not lightly that we took to weapons and rope to ensure the purity of our nation. Now, as we endure a murder rate that's the highest it's been in 47 years, as we face hordes of illegals and so-called refugees, it is of the utmost importance.
What? Why?
It is
What happened?
Excuse me?
Maybe to you, but not to a lot of people in the room. We never shut down any of the opposition. We're certainly not going to shut down the people.
Marauding savages and talking about lynching black people.
As we face hordes of illegals and so-called refugees, it is of the utmost importance that we be granted broad liberties to kill with impunity. It is our duty as brave Americans to strike down with finality any foe who dares frighten us. It is imperative that every true American has the authority to act without the stifling restrictions of law and order or due process. For too long, the forgotten men and women of America have cowered in fear of the other. I ask you to vote yes on HF 238 because it's time to stop being afraid. It's time to kill the scary people. It's time to make Minnesota lynch again. Thank you.
That, all right.
I'm ceding my time.
All right, come on. You've been good up until now. Yeah, that was rather offensive, but the last time we've had these hearings, if we shut anybody down on either side, we get booed and hissed, so I thought I'd just let them rave on. Go ahead.
I'm ceding my time to Nancy Nordbens.
What's that? Okay. Ma'am, if you could introduce yourself again and...
I'm Reverend Nancy Nordbens, new Executive Director of Protect Minnesota. And mainly today, I just want to speak in response to the presence of John Lott here. He has quite a national following, and I want to make sure that we all understand who just spoke with us. John Lott's deeply flawed research has been debunked repeatedly by respected academic researchers in public health, sociology, and criminal justice. Mr. Lott's frequent assertion that more guns equal more safety was thoroughly repudiated by a National Research Council panel as far back as 2004. When questioned about unlikely findings in a survey he claimed to have conducted in 1997, Mr. Lott blamed a hard drive crash and an office move for his inability to produce the survey data, the names of any of his research assistants, and the names of the undergraduates who supposedly made the survey calls, or even the phone records showing that the survey calls had been made. Indeed, Mr. Lott has become such a pariah in academia that he was reduced to using an assumed name. He took the name of a Mary Roche so that he could make positive reviews of his own books on Amazon. This fraudulent effort earned Lott a page in the Encyclopedia of Liars and Deceivers by Rolf Bolt, published in 2014. I've given you that page in your handouts. After losing face in academia, Mr. Lott founded and made himself president of the Crime Prevention Research Center, a pseudoscientific lapdog of the gun lobby. NRA board member and spokesman Ted Nugent is a secretary of his board of directors. None of his research should be given credence by the Minnesota House of Representatives, and I urge you to ignore it. Thank you very much.
Oh, thank you very much for saying that. Well, we don't really want to back and forth here. We're going to start off with the track. But
Mr. Chair, I just wanted to take a brief second and address the testimony from Mr. Kuhn, and that was not someone that I requested to be here, and just wanted to make sure that everybody in the committee room knew that. So,
thank you. Ms. Martins, you were going to substitute someone? Oh, okay, that was it. I'm sorry. Mr. Imam Assad Zaman? And let me know if I pronounce that wrong, sir.
That was fine. Mr. Chair, representatives, good morning. I am Imam Assad Zaman, Executive Director of the Muslim American Society of Minnesota. I come here today to urge you, to plead with you, and to beg you to reject Stand Your Ground House File 238. I have carefully read this bill. The current law has a sentence that says, quote, "The intentional taking of the life of another is not authorized by section 609.06, except when necessary in resisting or preventing an offense." This bill would delete that sentence from law. I am pro-life, and I question how can anyone who is pro-life be in favor of deleting a law that says the intentional taking of the life of another is not authorized. This bill allows a person to shoot to kill simply because they subjectively feel, quote, threatened. As an imam, as a clergy person, I can assure you all people are not rational at all times. Some people feel threatened by a hijab. Some people feel threatened by a religious cap, such as the one I am wearing, or by a hoodie. Some people feel threatened when a person looks at them funny. communities of color and immigrant communities are particularly fearful of this law, that it will be used as an open hunting season against them. An amazingly large number of innocent people of color have been shot and killed using the Stand Your Ground laws across the nation. Till today, no one has shown me even one instance where a black person has shot and killed a white person and has escaped prosecution using a Stand Your Ground defense. Is this bill racist in intent? Probably not. Is it racist in impact? Yes, definitely. Legislators?
Sir, your time is up.
Thank you.
Thank you very much. Cindy Olson from Madison Lane.
I'm going to cede my time to the next speaker since I've already touched on
To who?
this topic. To the next speaker.
Okay, Chantel Allen. And if I pronounce these names wrong, correct me when you come up.
How you doing? Good morning. Good morning, sir. No, that was right. Chantel Allen. I'm with Black Lives Matter, St. Paul. This same bill allowed for 17-year-old Trayvon Martin to be murdered and George Zimmerman to be free to continue to cause havoc on our society. How does this happen? Fear of a certain group of people, and specifically fear of black people. Whose fault is it that we're feared? Not black people's. It's the fault of our forefathers that needed to capitalize off black bodies by releasing Willie Lynch and making sure that every landowner adhered to that. It was our leaders during the Reconstruction that feared that the equal opportunity of blacks would bring, what the equal opportunity for blacks would bring by releasing Birth of a Nation, so that everyone across the nation could continue to fear black people. It was J. Edgar Hoover that feared our independence during the 60s and 70s, leading to execution of Dr. King and other great leaders that stood for civil liberties of blacks by having COINTELPRO. In today's age, we have the misrepresentation of Fox News and other media outlets. Fear of black people in this country is part of basically being patriotic. I'm a 43-year-old educator, and when I put this hood up, I'm feared. Passing a bill like this will create an open season purge on our community. Passing a bill like this will create mayhem in our streets. Laws and bills are supposed to be created to protect the rights of American citizens. Aren't we too citizens? Stand your ground is just another way for people to get away with murder. When the law reinforces these murders, then it becomes lynching. This is a Republican bill. Are you the party of Lincoln or the party of lynching? I oppose this bill.
Thank you very much for your testimony, man.
Thank you.
Okay, we have John Thompson, Fight for Justice. John, you here?
Starting to feel like I'm a family member here, man. I'm back again.
Good morning, welcome back.
Good morning. Thanks for having me, Mr. Cornish. I want to coattail what my sister Chantel said. That is my sister. I want to coattail what she said, but I want to put it a little blunt. You know, a lot of times you guys see me screaming and I'm yelling. You're like, who's that crazy man in here? And you confuse that with anger. It's passion. You won't see me in this room. You won't see me in this room opposing anything unless it has something to do with the oppression of my brothers and sisters. With that being said, House File 238, with all due respect, sir, it protects cowards. Yes. This protects cowards like George Zimmerman, Officer Geronimo Yanez, Scarcella, and any one of these guys that fear for their life. Listen, when I'm screaming like this, I put you in fear for your life. I'm a dead man, and all I'm doing is showing passion. All right? So you have to understand the black man, understand where I'm coming from. And I challenge you to take time to sit down and understand me. Stop thinking that getting my passion confused with anger. I lost a friend And the coward cops fear for his life is what he said. They stood up and said, mere fear for your life is not going to work for you today, Officer Yanez. Somebody stood up and said that. All right? I'm in fear for my life every day I walk out of the house. You know how much hate mail I get, how many people call me nigger in my inbox, how many times people tell me they're going to kill you, and all I'm doing is coming here and I'm showing you passion. This is what the end of the road looks like as far as hope for a black man. This is what it looks like. It don't get no better than this. I know my 2 minutes coming up, man. But I'll be back. I'm your cousin. I'll be back. I'm your nephew. I'll be back. I'm your grandson. We may share different skin colors, but we bleed the same color blood, brother. And I think this is a bill that we need to sit down and discuss more and more before you put it out there, because what you do is you give a coward a way out. And I'll leave you with this. I told my father a long time ago, I said, Dad, I want to go out and get a gun permit. I want to buy me a gun. And my dad said to me, he said, son, I want you to know the meaning of a gun. Before you make a gun purchase, the meaning and what it means to have a gun. The only reason you need a gun is to defend yourself. I'm 45 years old, man. I done talked my way out of so many butt whoopers, man. I don't need a gun. I promise you I don't. All right? And thank you.
Thank you, sir. Thank you. We let you run over there, so. Mr. Flaherty, the Executive Director of the Minnesota Police and Peace Officers Association. Director Flaherty.
Thank you again, Mr. Cornish, and for the record, Dennis Flaherty with the Minnesota Police and Peace Officers Association. We simply want to go on record in opposition to this bill, and our tremendous concern about the bill is officer safety and the threat that it poses to all cops across the state. Every day somewhere there are officers serving search and arrest warrants, and they do so hoping to have the element of surprise on their side, or as the bill refers to, by stealth. We are concerned about the mentality that will be established by this bill. Language in it that says the use of deadly force is not authorized if the individual, quote, knows, quote, that the person is a peace officer is extremely troubling to us. I can give you one quick example. It may be about 3 years old, but we had an officer in St. Paul along with several of his colleagues that went in to arrest somebody. They were clearly in uniform, announced their arrival, screamed their arrival, and when they went through the door, they were met with the individual they were looking for, but he was armed and immediately fired a shot at the first officer through the door. Fortunately, the officer was wounded and lives to tell the story, but that's the way police operate on these operations. We also do not like the major expansion on the definition of dwelling, which now is going to include garages, patios, and sheds, whether they're locked or unlocked, boats, motorcycles. We're concerned about deadly force that's going to be used against people who represent no real threat or danger to an individual, and a simple 911 call would suffice. And finally, we oppose how difficult this bill will be to wage a successful prosecution. Our colleagues from the county attorneys will, I'm sure, go in depth, but it would go from what would a reasonable person do to a very subjective standard of what they believed at the time. A standard a prosecutor, unless he or she is a mind reader, is not going to be able to overcome. Thank you for allowing me that time.
Thank you, Director Flaherty. And Jeff Edblad, Sandy County Attorney and President of the Minnesota County Attorneys Association. And Mr. Backstrom, did you wish to testify this time?
Yes, I do, Mr. Chairman.
Okay. You're next, and you're the final testifier. Go ahead, sir.
Mr. Chair, members of the committee, again, my name is Jeff Edblad. I'm the president of the Minnesota County Attorneys Association, and I appreciate the opportunity to testify this morning. While no one is more concerned about the safety and protection of Minnesota citizens than our state prosecutors and the Minnesota County Attorneys Association, a close look at the provisions of this proposal, as well as current law concerning the right of self-defense and the justified use of deadly force, leads us to conclude that this expansion is not only unnecessary, it would be harmful to efforts to prosecute dangerous criminals who commit violent crimes. Because the way this bill is written, it would apply equally to dangerous criminals as it would to law-abiding citizens in situations that take place outside of the home, and I would concede the balance of my time to Mr. Backstrom. Thank you.
Okay, thank you very much. Mr. Backstrom, we'll give you a couple of minutes.
Thank you, Mr. Chair. James Backstrom, Dakota County Attorney. Thank you for the opportunity to be here today. Our current laws in Minnesota are adequate to protect our law-abiding citizens in terms of exercising the right of self-defense. Today in Minnesota, a person may use deadly force without an obligation to retreat if it's done to prevent the commission of a felony in their home. When a person's not in their home, they can rightfully protect themselves by using deadly force to avert a threat of great bodily harm to themselves or another, provided they first attempt to avoid the danger if reasonably possible. In all situations, Minnesota's law today properly requires that the decision to use deadly force be reasonable and necessary given the gravity of the danger faced. These current laws make common sense, they're appropriate, and they should not be expanded. One of the most significant changes that this law would bring is that it creates, as Mr. Flaherty indicated, a subjective standard of the reasonableness of a person's actions in using deadly force rather than the objective standard under current law. In other words, the issue becomes what is in the mind of the person using deadly force rather than how a reasonable person would have reacted under the same circumstances. This law would allow a person to shoot first and ask questions later whenever they believe they're exposed to substantial harm, regardless of how a reasonable person would have responded under the same circumstances. Do we really want to encourage a driver who believes he's being threatened with substantial harm in a road rage incident to shoot and kill the other driver rather than calling 911 or simply driving away? I think not. Do we really want to presume that a homeowner has the right to shoot and kill an unarmed teenager who sneaks into their garage to steal a bicycle, as would be the case under this proposal? I think not. This law basically gives the citizens more rights to use deadly force than our law currently gives to police officers with less review.
Mr. Backstrom, your time is up.
So thank you. For all of these reasons, I would encourage you not to support this bill. Thank you.
Okay, we're going to start with member comments here, or questions. We got quite a list in sessions at 12:15, but I'm going to real quickly begin. First of all, the veterans issue. There was many veterans. I hate to use veterans and say veterans say this and veterans say that. I don't think there's any survey out there on veterans and what they think about guns. But I had many calls on the other side of the issue, the supportive side, but I don't use that as a barometer. I have no idea if there's more one or more the other side. The other thing is the chiefs of police have vehemently testified against every gun bill that I or anybody has ever brought up. The chief today seemed to support the permit to carry and gave a couple examples where it has worked. However, the chiefs, when the permit to carry was brought up years ago in 2005, vehemently opposed it and said blood would run in the streets, basically. So now I think they're learning that that's not true. And I think that they'll learn that if this law was enacted, it wouldn't be true either. So they're learning anyway. And the last one, I think that Mr. Backstrom completely mischaracterized this law, and I'm very surprised at his testimony because this doesn't change the definition of it. All it does is it changes the duty to retreat, but the other protections are still there, and the reasonable person thing is still there. So I'm very surprised at that testimony compared to scholarly testimony. So that's my comments. We're going to start out with Representative Newberger, and then we have probably 4 or 5 others. Representative Newberger.
Thank you, Mr. Chair. I just want to say thank you to Representative Nash for bringing this bill forward and allowing me to be a co-author on this bill. Very briefly, members, Article 4, Section 8 of the Minnesota Constitution requires us to take an oath of office to support the Constitution of the United States of America. That's the highest law of our land. part of the highest law of our land is the right to keep and bear arms shall not be infringed. I highly regard, I hold you in high regard, Representative Nash, for doing this, and I firmly believe that House File 188 and House File 238 help us to do that. Thank you.
Thank you. And Representative Considine, followed by Representative Dean.
Thank you, Mr. Chair. I'm correct that you are the author, Mr. Chair, of the current Castle Doctrine bill?
Well, there is no current Castle Doctrine bill. I'm not the author of it.
I'm sorry, I was wrong about that. But then the first testifier that came up, I believe he was incorrect, that current law does not require you to run out in 20 below zero, grab your children, and leave your premises when somebody breaks in your house. I believe at this point you are well within your rights to shoot that person. So I was hoping that you would correct it, but I thought you were also thought you were the author. Thank you.
Representative Dean, followed by Representative Becker, Finn, Lucero, and Pinto.
Thank you, Mr. Chair, and I'd like to express sort of my concern about some of the statements in some of the testimony. Dr. Lott came down and started putting forward all this racial stuff, which quite frankly, you know, there's a saying that Mark Twain said, there are lies, damn lies, and then there are statistics. You can twist statistics any way you want to try to make a cogent argument, and most people that are good at it and are trying to deceive people go straight to statistics. They don't even talk about the issue that's at hand. And Representative Nash, you disavowed in many ways the testimony of Mr. Kuhn, and that he wasn't someone that you invited to come and speak. But this bill and the previous bill give authorization to people like him, people that think like him, to act on their own behalf out of fear, out of disgust, out of racism. We can go on down the list to shoot somebody and then make an argument. You give them the argument through this bill. And the last thing I want to comment on is, Mr. Chair, your comments about driving around in Arizona with your gun on a bench and in your car, and that's not an issue. I just want to point out that you're a white man. You have, hold on guys, you have very different privilege in our society. We saw a young man that was recently shot by an officer in St. Paul. Philando Castile and Mr. Allen spoke to that point. And the point I will make is he had a permit to carry. He was telling the officer that he had a permit to carry, and he was shot. If we get rid of permit to carry, does that mean that, you know, more people are going to be fearful when a cop's pulled over if they have a gun in the car? Or are officers going to use that in a way that, you know, well, how did I know he had a permit to carry? There was a requirement, and I believe that Representative Hillstrom pointed that out, is what are officers going to have to do? So philosophically, I'm against these bills, but also I think practically, there's big problems with what these bills do as far to carrying firearms in our society. And you reference Heller, Mr. Nash. Heller, in the ruling, also pointed out it doesn't mean that it's totally anybody, anywhere, any condition, anything can carry a gun. So, so yeah, I'm kind of ashamed to be a representative and having to hear these types of bills when I believe there are much, much more important bills that deal with the safety of citizens in Minnesota. And thank you for the time.
Representative Becker-Finn.
Thank you, Mr. Chair. First, I wanted to thank Imam Zaman and Ms. Allen and Mr. Thompson for being here and sharing your testimony with us today. I think it's very important that we hear from people of color when we're talking about these bills. And to Dr. Lott, I think if you're going to continue to speak so much about Trayvon Martin and how much you care about protecting blacks, that it might be helpful to speak more with people like Mr. Thompson and Ms. Allen about the real effects and the way that the community actually sees these kinds of bills. Telling them how they feel about it is not really productive, and I think it's just really important to lift up the testimony of those folks today. So thank you.
If I could interject in there, I sent out an article, I think it was, I wish I could remember what it was called, but I believe it was a Somali person here in St. Paul that was organizing people to defend themselves and showing them how to get permits to carry, and was trying to, specifically people of color, to get permits to carry. So that runs on both sides. Representative Lucero. No, I mean, as well as there are people that are for it, there are people that are against it. That's all I'm saying. Representative Lucero.
Thank you, Mr. Chair. And I just wanted to briefly thank Dr. John Lott for being here today. Back when I was a truck driver, I used to listen to Dr. John Lott with his comments on the then Jason Lewis show, now great congressman from the 2nd Congressional District, Jason Lewis. But I wanted to thank him for cutting through all the hysteria to bring facts. Why pro-Second Amendment bills such as this one that Representative Nash is bringing forward is something that we should be in favor of to drive down crime. Thank you.
I apologize to Representative Lott. Usually when somebody is disparaged like that, we allow, like in a courtroom, a rebuttal. And unfortunately, we have no time for him to come down today and defend himself on his facts and his studies. All we had heard was a disparaging remarks were made about him. Representative Pinto.
Thank you, Mr. Chair. I guess I want to make sure we're really clear, as County Attorney Baxter said, this represents a big change in this, in self-defense in Minnesota. All sorts of ways, and we could get into that, but just one specific situation. If your teenage son goes over and wants to meet his girlfriend on the deck of their house, and her dad looks out the window and sees him, nobody else is out there, that is a presumption. It doesn't matter whether there is a reasonable belief that there's an imminent threat of substantial bodily harm. If he entered that area by stealth, if he snuck onto the deck, there's a presumption that the dad can kill him. Now, we can think of lots of other situations, we get into that, but I guess the point is just the county attorneys are right. This is a major change in this. And then the other point I just want to bring up, because the World Health Organization was referenced, I actually pulled up the homicide statistics, and just to confirm, the figure in the U.S. is way higher than, for example, any of the countries in Europe, except you really need to get pretty deep into the former Soviet Union before you get anywhere close to the homicide levels in the U.S. And as long as we're lifting up the World Health Organization, in that very same page they say one of the main drivers of homicide rates is access to guns, with approximately half of all homicides committed with a firearm. So I appreciate the reference to the World Health Organization. I think that they should lead the way. Thank you, Mr. Chair.
Okay, we'll let Representative Nash close. Representative Nash, in your closing, could you let us know if all hell is broken loose in any of the states that have enacted the permitless carry, or if what's going on there in those
Well, Mr. Chair and members of the committee, thank you for a very spirited and good debate. Thank you for the opportunity to share issues that are important to me and members in my caucus. It is a great opportunity for us to have conversation. I believe firmly that self-defense is a human right. It doesn't know anything about color. It doesn't know anything about geography. We each have an individual right to defend ourselves. And that is a very important thing that we need to note. And that, for that reason, so we can clarify the rules of engagement here in the state of Minnesota, that is why we have this bill. And with that, I thank you.
All right, took us 5 years or so to pass the permit to carry, and we'll work on this one until we get her done. Thank you very much. Meeting adjourned, and the bill will be held over for possible inclusion.